dignitaries on and off the dais, my dear friends. All India Lawyers Union is the largest organization of lawyers and law students and teachers. Organization is committed to save Constitution and to protect constitutional values. Several programs are being organized by All India Lawyers Union related to Constitution in general and other programs on legal issues and issues related to judiciary, etc. Today, we have Judicial Accountability and Constitutional Morality as our topic. As lawyers, we are disturbed and provoked by two recent incidents. First one was in September 11, 2024, where Prime Minister Narendra Modi performed Ganesh Arati in the residence of our judicial head of the country, the Chief Justice of India. The second one, a little bit later, Chief Justice of India made a statement in his hometown Pune that he sought assistance from his God to find a solution for Rama Janmabhoomi Babri Masjid dispute in Ayodhya. Further, he stated, it is with the help of the God he could deliver that verdict. It is in this backdrop, All India Lawyers Student High Court Committee decided to schedule this program. Why so? Adding fuel to the fire, some other developments also there. That is the criticism by the Chief Justice of India against V.R. Krishna. V.R. Krishna is the greatest legal luminary and jurist our country ever seen. That criticism was made when the Chief Justice, along with 8 other judges, considering a petition under Article 39B of the Constitution. Then and there, 2 judges, Nagaratna, very strongly criticized the mode adopted by Chief Justice against Justice Krishna. And these 2 judges, in their dissenting judgment, then and there objected the criticism made by the Chief Justice of India. This is the scenario of our judicial system today. As lawyers, we are very much concerned of these challenges against the constitutional values and constitution. I hope the new developments has enhanced the relevance of our subject today. Today we have got Ad Kaleeswaram Raj, a prominent lawyer practicing various high courts and Supreme Courts, who needs no introduction. Our High Court is very familiar with Kaleeswaram Raj. He is the person who is interfering with the legal issues when the judiciary and other authorities deviating from the right path of the judicial system. For on behalf of this columnist, renowned columnist and speaker, for on behalf of All India Lawyers Student High Court Committee, I extend a warm welcome to Ad Kaleeswaram Raj. Today's President is the President of All India Lawyers Union High Court Committee, Advocate M. Shashindra. I cordially welcome Shashindra this function. Advocate N. Manoj Kumar, the State Attorney and State Joint Secretary of All India Lawyers Union is present. I extend a warm welcome to Advocate Manoj Kumar. Advocate C. Unikrishnan, the State Secretary member of All India Lawyers Union is on the stage. Warm welcome to C. Unikrishnan. And Advocate Deepa, who is our State Committee member. She is on the dais. I extend cordial welcome to Deepa. Of the dais also there are so many dignitaries, including the DGP and the senior law officers are there. Several newcomers, new faces also there. Similarly, Shantama is attending our function. I extend warm welcome to all our present here. Thank you.
Our speaker, Ad Kaleeswaram Raj, my friends on and off the dais. Our topic of today is judicial accountability and constitutional morality. We know that in our constitution, there are three recognized pillars of the state. They are judiciary, legislative, and executive. And there is another fictional pillar called fourth state, the press. Due to emergence and excessiveness of visual media, the sanctity and credibility of that fourth state is practically lost almost. Whenever there is exuberance of excessiveness, we know that history says that there will emerge somebody to save the institution itself. So we can hope that somebody will emerge within the fourth state to rectify the anomalies and mistakes being committed by that fictional organ. Coming to the other constitutionally recognized pillars, legislative, judiciary, and executive. There has been Cold War to find out who is prominent and who is important. The question as to the supremacy of one of the organs is still a conundrum. When executive goes wrong, judiciary can step in and rectify the executive. When legislature also goes wrong, to an extent, judiciary can step in. But what about the judiciary? There is no effective forces or mechanism for curbing or restraining the judiciary if it commits mistake. So, as I said earlier, there should be a mechanism inside the judicial system, and people have faith. The common man, the people have faith and belief in the judiciary to protect the country. And when there is a belief, when belief is there, we are believing in something, there is no question of further inquiry. We believe as if it is truth. So the credibility and honesty and impartiality of the judiciary should be retained. If there is some suspicion on it, the entire democratic system will collapse. So it is our duty, as part of judiciary, to initiate a mechanism or take initiative to rectify the mistake or anomaly being occurred in the system itself. In the context of the recent developments in the periphery of judiciary, the Lawyers Union, All India Lawyers Union has selected this subject, and we have got a right speaker on it. I invite thinker, writer, and orator, Ad Kaleeswaram Raj, to deliver the speech on the subject.
Mr. Nasa, Ms. Manoj, Ms. Deepa, Mr. Krishna, and after that, Mr. Yusuf, my friend Mr. Shaji, Shandama, and all other side will take the whole time for mentioning each and every name, many of which are familiar to me, many of which may not. I'm glad to be here to deal with a topic of contemporary importance. Sorry? You can hear me?
Yes, sir.
There is some physical limitation for the mic, and that cannot be helped. So the topic given to me has been rightly indicated by Mr. Shashi and Mr. Nasser is of some sensational point in the kind of judicial sensation. Even otherwise, it has a kind of constitutional significance with which we are all concerned. I rather would like to start with a narrative which my friend in Delhi, Mr. Sanjay Hegde, happened to pen recently. He was talking about an incident which occurred in the veranda of the Supreme Court. A litigant came after all the security check and all, it's the tedious process, you know that, to reach inside the Supreme Court. Then he was seeing the Supreme Court for the first time and seeing the judges of the Supreme Court for the first time. He physically felt the kind of power which each and every Supreme Court judge was exerting while hearing the matters. And to some years ago, when many of the judges were more rigorous and formidable, and he asked, after seeing these judges, he asked, what is the difference between God and the Supreme Court judge? Very innocent question. And somebody answered him, saying that the God doesn't think that he is a Supreme Court judge. This precisely means several things. One aspect is that because of the wide power of judicial review in India, we have perhaps the most powerful Supreme Court in the world. Therefore, it is metaphorically creating persons who are as capable of or more capable than God in the conventional sense. God, of course, has attained some new dimensions and new definitions in the recent occurrences which we shall deal with. separately. But this being the position, we expect the judges of the Supreme Court to act constitutionally, on and off the bench, and even to live constitution. It's not enough, perhaps, to write judgments which are constitutionally correct. It's also necessary to ensure that they lead a judicial life, both personal and professional, which is constitutionally correct. Which, of course, is a very, very tedious task, which calls for several kinds of sacrifice from the bench. So, when we discuss about the legacy of the Chief Justice, which is one of the most prominent topic in the recent days, we also discuss about accountability, the questions of related to morality, constitutional morality, etc. On Chief Justice Chandrachud, let us talk something which is in the form of an encomium. Several things which can be said and which are to be said rightly in favor of the Chief Justice, let it not be forgotten. And a valid objective criticism will always happen by telling things which are good as well as which are not so good. Chief Justice Chandrachud has no doubt imported a kind of modernity in the Indian Supreme Court, in the technical sense and also in the substantial sense. Some of the judgments which Justice Chandrachud authored, especially in the earlier years of its innings, reflects a kind of judicial modernity. When Joseph Shine was decided, when 377 matter was decided, you find a kind of constitutional morality replacing popular morality, replacing social morality. The problem, however, is how do you maintain the kind of constitutionalism when you are confronted directly with an aggrandizing state? This is a natural problem with Indian Supreme Court, or with other high courts, which again are constitutional courts. People have yes. In the case of Indian case, yes, I think it is better now. So, of course, when Bhima Kothari case came, then Justice Chandrachud only wrote the dissenting judgment in nomina case, granting bail to the accused in the famous case. But because it was a minority judgment, it didn't have any effect, and the consequence of which we know through Stan Swami or through Sai Baba, etc. And several other cases where innocent persons were incarcerated. There is even a book on incarcerations in the recent times, Al Pasha. It has written an extensive work in the context of Bhima Court. When directly the court was in conflict with an aggrandizing state, what could be done? Several judgments of the Supreme Court came when the period was so peaceful, or rather, the court enjoyed a kind of judicial comfort to write the judgment. Take for example Bommai. When Bommai was decided in 1994, the issue was rather academic, because Bommai case arose at a time when, you know that, 6 states in the north faced trouble from the center. The trouble occurred because the Karsevaks were given a direct support by the state governments in the north. Madhya Pradesh, Uttar Pradesh and Rajasthan. Sorry, Madhya Pradesh, Himachal Pradesh and Rajasthan. It so happened that the state governments were dismantled by the center, because even the court orders were not honored. Babri Masjid was demolished and the Karsevaks were given open support by the state government, violating all the tenets of secularism as laid down in the constitution. This provoked the central government to dismantle the state government. But at that time, when the challenge was made, and certain other state governments were dismantled on account of dispute with respect to majority on the floor. But ultimately, when the cases came before the Supreme Court, there was a series of cases. And in 1994, when the Supreme Court decided on secularism and federalism, the issue on the ground was no longer. That is to say, the court was in a comfortable position to have a rhetoric on the constitutional principles. Again, when you decide right to privacy in Puttaswamy, court is again in a comfortable position so that you can have all kind of constitutional rhetoric on the subjects. But when a fragile person like Sai Baba was jailed, fragile in the sense, person suffering from 90% disability was jailed for years together, and when he repeatedly pleaded for bail, for treatment, the most powerful Supreme Court in the world was helpless. Again, same thing happened with Stanford. These are all cases where center or its agencies, especially the fourth branch agencies, which are no longer independent, say like CBI or ED or the National Anti-Terrorist Organizations. These are all not acting independently. When the center is so particular that certain person should be in jail, and even the charge sheets in UAPA cases run into thousands of pages. It's a very strange thing. No court could ever say that a charge in a criminal case should not be like this. We all know the fundamental thing of criminal law, that the charges also, as an administrative law, charges should be specific, clear and brief. UAPA charges often run into thousands of pages, which requires logistics to get transported. And very often this takes months together to get finalized. And during that period also, the accused are in prison, are incarcerated indefinitely. No court could come to the rescue of such persons during these years. Because essentially, in such situations also, the court, as Mr. Sashi indicated, is not accountable to anybody in the country. And given that, and coupled with that, we have a fragile media and an inert populace and a majoritarian blindedness at the end of things. Even when this was agitated, you know, the first acquittal by the Bombay High Court, when that reached the Supreme Court, in an infamous Saturday hearing, after Gogoi's Saturday hearing, it so happened that the judgment was stayed. That is to say, after years, several years, the Supreme Court interdicted and acquitted by the Bombay High Court in the case of Sai Baba, which took him back, or rather, to be accurate, which retained him in prison. And in Stan Swami's case, for getting a straw, it required a long litigation, which again is not contemplated in the constitutional scheme of things. So these are the realities. To put it bluntly, when the confrontation is directly with the state, with the executive, which is the most powerful and most dangerous branch, Alexander Hamilton famously said that division is the least dangerous branch. And together with that, we know that the executive is the most dangerous branch. And when the least dangerous branch is confronted with the most dangerous branch, it so happens that the most powerful Supreme Court in the world becomes helpless. This is where these are all the situations which we invoke to assess the legacy of the Chief Justice as well. Of course, as I said, he has modernized, he is well behaved in court. Any lawyer gets an equal, fair treatment in CJE's court. That's a very big, commendable thing as far as the Supreme Court is concerned. There's no doubt about it. But when history evaluates persons, the history always uses tools of its own, and the scales are always larger. And many other individuals who were in jail faced the same predicament, including those in Bhima Koregaon case. Then there are situations elsewhere, like Umar Khalid or Biju Kapan, the Kapan's case from Kerala. In many other cases where the accused was charged under the anti-terrorist law like UAPA, where the bail conditions are stringent. Earlier, even sedition law was invoked, 124A. Even against minor girls, like students, they might have just crossed, technically they might have crossed 80. On Amulya, the Disha private activists. It so happened with that. The strategy of jailing started with these innocent persons. Then it went on to Bhima Koregaon case. Then to the journalists, thinkers. Nobody questioned. Mainstream politics also was relatively mum on that. Then, as it is famous, then they came to know at our law. The chief ministers were taken to prison. Right in mainstream political political level, persons were taken during their age. And this invocation of PMLA, with its stringent provisions, made a story of its own. What could be done by the Supreme Court in general and by the Chief Justice in particular in such political cases, glaringly political cases, is a question which will haunt the institution for a long time. When we talk about accountability, we also talk about the experience, the judicial experience which the country has undergone in terms of liberty. People are essentially afraid of talking. Even one of the most prominent industrialists in the country, Rahul Bajaj, said that we live in an atmosphere of fear. When it's an atmosphere of fear, people don't talk as it happened during the national emergency, the third emergency during 75-77. That takes us to the unanimity of the Grewar as it is famously said by jurists. And it happens in the entire country. When the labor laws were rather hardened as against the interest of the working class, when the CAA amendment, Citizenship Amendment Act was promulgated, and when the agitation started against that, many of whom were imprisoned on the ground of sedition and sometimes even on the ground of UAPA. It so happened that an atmosphere of fear had been created in the whole nation. The test of constitutional morality and the test of accountability lies in what the Supreme Court was able to do in the cases of such direct confrontations. It is a sad thing to note that when Sai Baba's case was taken on Saturday, and when it was Mr. Basan from our state who argued for Sai Baba, when Mr. Basan said that he is a 90% disabled person, the acute comment came from Justice Shah, M.R. Shah, who is now retired, was that such persons could be more dangerous. And Sai Baba is no longer there. This tells a very, very sad commentary on the system. The Supreme Court is powerful only when the court enhances the aspirations of the people at large, not when it prefers a few over the majority interest. Even during this talk, Mr. Nasser said about the recent judgment, property owners case, which is the latest one which is in our mind. Property owners case is not as if Justice Krishna cannot be criticized. Justice Krishna can be criticized. We all do that also. Justice Krishna was criticized for the ambivalent, so-called ambivalent order during the in the Viratnarayan's case, and about his judgments with respect to death penalty, where he quoted the judge to indicate his helplessness because we are not implementing the laws of our dreams. We can only implement the laws of the land as it is. For all these things, Justice Krishna was criticized, and there is absolutely no difficulty in accepting a valid criticism against Justice Krishna. But the problem with the property judgments is rather interesting. Because it is having some contextual relevance, I will take you to just 2-3 very brief passages in the judgment. Justice Krishna quoted Karl Marx in the old judgment, the Karnataka judgment. And this is what he said: the taking over of large conglomerations of vacant land is a national necessity if Article 39 a constitutional reality. Law can never be higher than the economic order and the cultural development of society brought to pass by that economic order. Quote unquote Marx. This is what Justice Krishna taught. There is absolutely nothing wrong in quoting Karl Marx in a judgment. Very often, let us be assured that very many principles in the Constitution can be taken as manifesto in this case. I can tell with greatest sense of responsibility that Part 4 Directive Principles, Articles 38 onwards till 51, in one way or other, reflects facets of constitutional socialism, which may be different from political socialism, of course, which Dr. Ambedkar himself said. Dr. Ambedkar said that we are implementing socialism in terms of law and constitution. This is what Dr. Ambedkar famously says. So it is not as if these things of political ideology are alien to the Constitution of India. This is why Justice Krishnaiyer fought the demands. And that was the context of 42nd Amendment, where the word socialist was specifically incorporated with the preamble. There was nothing new which happened with the 42nd Amendment in 77. It was just a repetition or reiteration of what has already been laid down in the directive principle, which talks about monopoly, against monopolization of wealth, equal pay for equal work, welfare measures for workmen and women, education for children, etc., and protection of environment. These are all things which could be termed as aspects of scientific socialism in the political sense, or as the constitutional version of these things. This was criticized by Justice Chandrachud. Krishnaiya's judgment, again, Justice Dhulia has written very fascinating in a very fascinating way about this. The question was interpretation of Article 39B, which says about the material assets belonging to the community, which should be used according to the article for the welfare of the society. For common good is the word used in the Constitution. Justice Krishnaiyer said the idea of individual property is something which is not acceptable going by our constitutional scheme, at least in the Constitution. You may possess the property, that is a different thing. But to say that it will always remain from constitutional dealing is not correct. Was the approach which Justice Krishnaiyer adopted in the Rangarajan judgment. Then Justice Krishnaiyer expanded it to say that the public property means something which is purely private. It cannot be conceived in a constitutional democracy, because for the reason that the interest of the state, when it reflects the interest of the public at large, is the constitutional interest which requires safeguard. This was precisely the reasoning of Justice Krishnaiyer. And of course, the 77 judgments is a marvelous read for anybody who is interested in constitutional. That was, in fact, not a dissenting judgment. It was a minority judgment, but it cannot be termed as a judgment in dissent for the reason that the majority of the bench didn't deal with petty. In the Karnataka case, state of Karnataka case, there was no dealing with the issue of 39B by the majority. Therefore, there is no question of this acting as a minority judgment or the point issue. That doesn't happen yet. Therefore, there was no impediment for the subsequent benches. This is what Justice Chinnappa Reddy said in the subsequent 2002 judgment. Justice Chinnappa Reddy followed Justice Krishnaiyer and adopted the same approach which Justice Chandrachud calls as the Krishnaiyer doctrine. And in doing that, what Justice Chandrachud said, these are questions of economic and social policy which fall outside the ambit of judicial inquiry. Then he said, as noted above, the court must not stretch into the domain of economic policy or endorse a particular economic ideology while undertaking constitutional interpretation. This was the main criticism posed against Justice Krishnayer's view in the Karnataka case. Let us now come to the passage where Justice Chandrachud says about this issue. That is paragraph. That's an interesting thing. Justice Chandrachud said in paragraph 260, this will probably give a complete answer to our dilemma on whether the judgment request will be criticized or not. Justice Chandrachud, 400 of the majority report, India's economic trajectory, paragraph 260, indicates that the Constitution and the custodian of the Constitution, the electorate, have routinely rejected one economic dogma as being the exclusive repository of truth. As participants in the vibrant multi-party economic democracy, the people of India have voted to power governments which have adopted varied economic and social policies based on the country's evolving development priorities and challenges. The foresighted vision of our framers to establish an economic democracy and trust the wisdom of the elected government has been the backbone of the high growth rate of India's economy, making it one of the fastest growing economies in the world. This is read not from the Prime Minister's speech. This is being read from the judgment of the Supreme Court by Justice Chandrachud, which criticized Justice Krishna Iyer for holding a particular political economic view. This shows the irony of the judgment. And this is and Justice Chandrachud further says, to scuttle this constitutional vision by imposing a single economic theory which views the acquisition of private property by the states as the ultimate goal would undermine the very fabric and principles of our constitutional framework. This is what Justice Chandrachud wrote in the recent judgment. Then his criticism of Justice Krishna Iyer, as noted above, this court must not tread in the domain of economic policy or endorse a particular economic ideology while undertaking constitutional interpretation. This is the criticism against Justice Krishna Iyer. To hold that the term distribution cannot encompass the vesting of private resources would amount to falling into the same error as Justice Krishna Iyer doctrine, that is to lay down a preference of economic and social policy. To put it bluntly, it is the same error which Justice Chandrachud also committed in the majority judgment. He favored a policy, an economic policy, which he says has been successful, which again is a contestable proposition. Everybody may not agree that the country has been doing marvelously well during the last few years. We have poverty, we have unemployment, we have inequality. Some, of course, might have been growing up and up, but that doesn't mean the country is progressing economically. That's a prominent view, which is reflected to a good extent given in the last election. Not even in the election. So that the economic growth is a reality, that the entire electorate has supported it, doesn't make sense when you are having a hung parliament. So this is a bad kind of message to those who are concerned with constitutional law and constitutional adjudication. I would say that the real problem has happened inside the judiciary. I have an opinion that very many of the problems connected with the country's judiciary is connected with the way in which we select our umpires. It so happens that when the Constitution didn't tell in clear terms about the method of selection of judges. I have a point on that, namely, Article 217 or 124 only talks about appointment of judges. Who has to appoint the judge? It is the President. These articles don't talk about the method of selection of the judges. This is therefore an area where there is some kind of constitutional silence. None of the Supreme Court judgments, right, starting with S.P. Gupta in 1982, then the second judge's case in 1993, third judge's case in 1998, and the NJAC case in 2015, was trying to understand this constitutional vacuum. Therefore, it so happened that when it was essentially a matter for the legislator to ponder over, it so happened that the vacuum was filled up by the Supreme Court by evolving a system of collegium, of which also Justice Krishna was an ardent critic. As he was usually to say, we are the only country in the world where the judges select the judges. Of course, the executive may be having a say. When the executive is more powerful, it may be having a double say. That's a different thing. But technically, because of the second judge's case in 1993, as clarified in 1998, we have a situation where the judges essentially select the judges. With this process, it so happened that unless and until you are in the good book of the judges, you cannot aspire for an elevation. You don't find a critique of the system ever, perhaps after Krishna, being elevated to the system. Someone calls it as, and very many times it so happens that the judges want people in their own images to get elevated. This will precisely mean that a good part of the criticism about the judiciary, about the working of judiciary is rather stalled because of the institutional mechanism, including collegium and the way in which the judges are selected. People want to be, lawyers also want to be in the good book of the judges, and nobody wants to be rather known as a troubling person. It so happens for various reasons. And often it is said, because the judges select the lawyers in their own images, who are rather disciplined means who are sufficiently subordinate, who are not critical, who are obeying, and who are essentially silent. This is called as a process of homosocial morphing. The lawyers are taken by a process of morphing, and the morphing happens by resorting to an inquiry for the persons of their own category, of their own traits. And this has drastically affected the internal judicial democracy. Even F.S. Nariman was usually to say that we always want to please the judges. He taught it in a joking fashion. We don't want to be known as critics of the judges. He said it in a later way, but he said it. The result is that whatever troubles the system have get perpetuated. Mediocrity is very large. And as a result, very many young blood who read the profession or who read the court get disappointed. Where merit is not honored, that gives a very bad message. This troubles the idea of judicial accountability, because judicial accountability is something ensured only when there is a dissent or where there is critical intellect, as Umberto Eco famously called it. When you require only the kind of subordination, the system doesn't develop. Sycophancy or mediocrity can only satisfy certain individual aspirations, not the institutional growth. And what did the judges of the Supreme Court do about it? What actually did the outgoing Chief Justice do about it? What is the representation of Dalits, of women in the higher bench? These are questions which will have to be asked when we talk about accountability. And the answer, I'm sure, is definitely disputed. Therefore, it so happens that when you talk about constitutional morality, it is very easy when you do it in terms of attendance, because the state is not that much adversely affected by that. Even when Aadhaar was decided, 90% of the Aadhaar project was completed, and so again, therefore, the state is not affected. The question is to have a consistent, integrated approach to issues, even for the courts. We know what happened to the hate speech case. I can tell something about Justice Joseph's orders, K.M. Joseph's orders, who is regarded even now as one of the most honest judges which we had in the Supreme Court. He only issued the order to register the FIR when he even said from the open court, even if it is said by Prime Minister Modi, you know that I directly read. People in North York have restored it. Can the Supreme Court say this kind of things about Prime Minister? They cannot even conceive that. Because of the peculiar model of Kerala model of judicial development, we had Justice Joseph to say that. But what happened ultimately to the hate speech case? The case is not even being taken. There is a kind of conscious inertness in the matter. And all of us know what happened during the last election and who was the prime case speaker in the election campaigns. The court didn't do anything. Then came Justice Joseph, another judgment. He interpreted, where I also appeared, Article 324(2), talking about the appointment of election commission. Justice Joseph said, taking a clue from the earlier judgments, Justice Joseph was in the vigilance appointment case as well as the CBA chief appointment cases. Justice Joseph said that 324(2) says about the appointment of election commission by the president until the parliament makes a law on that. This is the text of Article 324(2). Then Justice Joseph synthesized over that to say that till such law is made, you cannot have a system like this, where the Prime Minister essentially appoints the election commission. Prime Minister plus another cabinet minister, then the opposition leader. This is the committee. The result is that it is essentially a Prime Minister's choice. And the Chief Election Commissioner, as well as the election commissioners, are appointed essentially by the Prime Minister. Justice Joseph says in Anup Baranwal, Constitution Bench judgment, that this cannot go on any longer. And you make a law on this, and until you make a law on this, not merely making a law, you make a law in terms of the idea of independence of the election commission, as we have laid down in this judgment, which is rather a treatise on the subject, I would say, you make a process which ensures the independence of the Election Commission. And till that process is done, that the Chief Justice also be in the committee, so that it will no longer be a Prime Minister's committee. This was the crux of the judgment in Anup Baran 1. We all know what happened after that. The centre came with a legislation in 2023 that replaced the Chief Minister, the Chief Justice again, with the Cabinet Minister, and reviving the whole situation. We contested that. The act was challenged. The quick appointment of election commissioners, including the commissioners who are now holding the field, were challenged before the Supreme Court. And we relied heavily on this constitutional judgment in Anup Baran 1. The appointment was not annulled. Stay was declined, which meant that when the executive decided to sabotage the constitutional bench judgment, the Supreme Court turns helpless. This is again antithetical to judicial accountability.
Electoral bond case. By the time the electoral bond was, that of course in principle is a radical judgment, there is no doubt about it. But the problem is that the judgment was delivered at a time when the world's richest political party reached its economic saturation. And when there was a request to conduct a probe into that part of the prayers was not heeded to, even in the electoral bond judgment. Therefore, practically, it resulted in perpetuation of the status quo, which is not something which one can be happy about. These are all the prominent things. I don't want to take further time from you on this talk. Suffice it to say that for safeguarding judicial accountability as well as the constitutional morality in the most severe situations of unfreedom and political attacks, or rather the situations where the regime is armed with purse as well as the sword, it requires constant vigilance to see what is happening in the judiciary, what is the level of accountability, what is the level of constitutional morality. Justice Robert Jackson famously said, quote, "It's not the function of our government to keep the citizen from falling into error. It is the function of the citizen to keep the government from falling into error." My request is, please substitute the term government with court. It equally applies, what Justice Jackson said, equally applies to the judiciary. Thank you.